Hello, are you ready to take the next step in your U.S. immigration journey? I'm here to help. My name is Kulen. I'm an immigration attorney for over 20 years of experience. I've helped thousands of individuals and corporations with their immigration matters. Today, I'm going to explain you how to file for a green card application after you get married to a U.S. citizen or a green card holder. This is one of the few ways of getting a green card application, but you have to make sure that your marriage is real and you can prove it. So what are some of the requirements of the green card application? What do you need to be careful about, and how long does it take to get the green card? First of all, if you get married to a U.S. citizen, you don't need to wait for visa numbers to become available. However, if you get married to a green card holder, then your visa application is subject to visa availability in the F2A category. The reason for that is there is only a certain number of green cards that can be issued every year, and there's a lot of applications filed in that category. So you will need to wait for your line to be able to get the green card. So what are the steps of filing a green card application? The first application is called I-130. This is the number of the form filed with the Immigration Service. The I-130 application is named after the number of the form filed with the USCIS. This is the U.S. citizen or green card holder spouse's application establishing that the marriage is real and that he or she is filing for a green card application for the foreign spouse. The second step of the application is called either 485 application or consular processing, depending on where the foreign spouse is. If you are in the U.S. and you can adjust within the U.S., meaning you can get a green card within the U.S., you can file a 485 application. If you are outside of the U.S., then the application is called consular processing. Typically, the 485 application, which is the second stage of the application, can be filed concurrently with the I-130 application, together with the I-130 application, if the filer is a U.S. citizen spouse. If you are married to a green card holder, you need to wait for your visa availability in order to be able to file the 485 application, and you need to make sure you are in status in the U.S. This is the main difference between a U.S. citizen spouse or a green card holder spouse, because if a U.S. citizen spouse is filing the application, they can file it together with the I-130, regardless of the status of the foreign spouse. They may be here on an overstay visa. As long as they're not inadmissible, then they should be able to file an I-485 application. On the other hand, the green card holder spouse must be living in the U.S. in a valid non-immigrant status and shouldn't violate their status until a 485 can be filed. When can you file a 485 for your spouse if you're a green card holder? You need to make sure that your priority date is current by checking the visa bulletin. The visa priority date is established by the filing of the I-130 application. So once you file the I-130 application, that's your priority date. And once your priority date becomes current in the visa bulletin, then you can file the 485 application. Of course, as I've explained, for U.S. citizen spouses, the visa availability is a non-issue. You can file the I-130 together with the I-485 application. If you're filing a 485 application within the U.S., you need to include the foreign spouse's personal documentation, such as birth certificates, anything that shows how they entered the U.S., what their current status is, etc. If you're filing a 485 application for the spouse of a green card holder, you also need to file documents showing that they are maintaining their status until the date the 485 is filed. So once you file the I-130 and 485 together, they are typically adjudicated together. Typically, USCIS issues an interview, and both the foreign spouse and the U.S. citizen or a green card holder spouse attend this interview, where they need to establish that their marriage is real. The USCIS officer goes through the application forms and documents to make sure that the marriage is real. The USCIS officer can ask questions about how the couple met, where they live together, their living arrangements, etc. It is important to note that while you are filing for an adjustment of status, you can also file for an employment authorization document as well as an advance parole, which is an international travel permit. For applicants within the U.S. who are filing as an adjustment of status, the adjudication of the case can take anywhere between 4 months to 12 months. Our record in such a case is 2 months, where the foreign beneficiary spouse was able to get the green card in 2 months without an interview. However, the usual time to get an employment authorization document is around 3 to 4 months, and the usual time travel document is around 8 to 12 months. You may be asking this question: if I'm getting the green card within 4 to 8 months, why do I need the employment authorization or the advanced parole? And the answer is you don't. Sometimes you get the green card so fast, they didn't even adjudicate the employment authorization document or the travel document. So you get a denial on the employment authorization and the travel document because you already have the green card. I hope that happens to you as well. It is important to note that all USCIS officers conducting these marriage interviews are trained in fraud prevention. Indeed, marriage-based cases are scrutinized by USCIS due to the potential for abuse. If there's an interview scheduled, the officer will go into the details and talk to the couple about their relationship to make sure that the marriage is real. What happens if the foreign spouse is waiting for a green card interview outside of the US? This procedure is called consular processing. As opposed to adjustment of status, which is in the US, this application cannot be filed concurrently. Once the I-130 is adjudicated by USCIS, it is then forwarded to the National Visa Center, which is part of Department of State. National Visa Center then collects some documents from the US citizen or green card holder spouse and the foreign spouse to make sure that they are interview ready to be able to forward the case to the consulate where the green card interview will take place. Once the I-130 is approved, the transfer to NVC usually takes anywhere between 1 to 3 months. The NVC usually collects the documents within 1 to 3 months. This also depends on how fast you are to be able to provide these documentation. The document collection is done online, and once the document collection is completed, then NVC will send you an email that the case is documentarily qualified, and then they are waiting for news from the consulate to be able to forward that case to the consulate. Once the case is documentarily qualified, NVC will then wait for a request from the consulate saying that they have availability for the green card interviews. Once NVC gets that kind of notification from the consulate, NVC will then forward the case to the consulate. So here it is first come, first served. The green card interview at the consulate is a little different than the interview at the USCIS. First of all, you will definitely get an interview at the consulate. In the USCIS, when you're doing an adjustment of status application, sometimes interviews are waived. At the consulate, it is never waived. The second most important difference would be you are going to attend this interview on your own. The US citizen spouse or a green card holder spouse is not supposed to attend this interview. It's only the foreign spouse. The US consulate interview can take anywhere between a few months to a few years, depending on whether your spouse is a US citizen or a green card holder. Because if your spouse is a green card holder, you need to wait for your visa availability, and NVC may hold on to the case until the consul lets them know that the visas are available and they are conducting interviews for that specific case. A very important step in all marriage green card applications is the concept of financial support. The U.S. citizen spouse or a green card holder must sponsor their spouse in order for them to come to the U.S. and get a green card. This financial sponsorship requires the U.S. citizen spouse or the green card holder spouse to fill out a Form I-864 affidavit of support. If your financial status is not sufficient to be able to sponsor the foreign spouse, then you will need a joint sponsor. The joint sponsor must be a U.S. citizen or a green card holder and must be living in the U.S. and must be earning enough money to support his or her own family as well as the foreign spouse. Marriage-based green card applications require meticulous preparation, and it involves a lot of different steps. Therefore, you need to work with an experienced immigration attorney. I have consulted with many couples where they tried to do it themselves and were not successful in either submitting the documentation or getting the case processed or moving the case forward. And also, every couple's situation is different. You need to be strategizing according to your living conditions, financial situation, as well as whether you are in the US or you're outside of the US, and where you're going to get married and where you're going to file this case. Therefore, I always advise my clients and my potential clients to get a consultation from an experienced immigration attorney, and always file your cases with the help of an experienced immigration attorney. If you're thinking about getting married and you want to know your options, please get in touch with us. For the latest updates on immigration, please like this video and subscribe to my channel. I hope to see you in my next video.